Good evening. Welcome to the National Constitution Center. My name is Stephen Frank. I'm the Director of National Programs. We're very glad that you have joined us during this most auspicious week when we celebrate Constitution Day, the day we signed the document 221 years ago that forged this nation and changed the course of human history. We have a glorious week here at the Center full of activities and programs around this important day, but undoubtedly the highlight is upon us. We are about to hear from Dean Harold Koh, one of the most distinguished legal scholars in the country, a leading expert on international law, and a prominent advocate of human and civil rights. To introduce the Owen J. Roberts Memorial Lecture tonight is a man equally distinguished, Michael Fitz, Dean of the University of Penn Law School. Before this building even opened, the Constitution Center and Penn Law teamed up to create a visiting scholars program that has brought legal luminaries to both our institutions to educate law students and the public. Now we are proud to partner with the law school to present an endowed lecture that has reflected the best in legal thinking for half a century. Dean Fitz will join us in just a moment, but before he does, we'd like to play for you a brief message from the chairman of our board. Thank you again for joining us this evening, and we hope you enjoy the lecture.
Participating in the following program, you're celebrating one of the greatest rights the Constitution gives us, the right to freedom of speech. Our democracy can only flourish through the knowledge and active participation of our citizens. A visit to the National Constitution Center gives you the opportunity to learn through rare artifacts and hands-on exhibits about the history of our government and our nation. It's an inspiring story of how we, the people, have made and continue to make this country succeed. I encourage you to visit the museum and discover this jewel of America that brings the message of our Constitution and the story of we, the people, to life.
It is now my pleasure and honor to give you Dean Michael Fitz.
Well, welcome. It's really a pleasure to see all of you here for the Owen J. Roberts Memorial Lecture. I'm delighted to see such an illustrious group here this evening. It truly is a very special event. The Roberts Lecture is Penn Law's oldest and most distinguished lecture. It was endowed over half a century ago by the law firm of Montgomery McCracken to honor its co-founder, Owen J. Roberts, a Penn Law alumnus. As the location of this year's lecture signifies, we've partnered with the National Constitution Center in presenting this during Constitution Week. And we also, I must mention, are holding this lecture in a very famous room at this point. This is where Senator Obama gave his celebrated speech on race relations in the United States. Owen Roberts is really an ideal namesake for this lecture. He served his country with manifest distinction. By special presidential appointment, he conducted exemplary investigations into some of our country's most difficult problems, the Teapot Dome scandal, as well as the attack on Pearl Harbor. He later served on the United States Supreme Court during one of the most difficult periods in our history, during the U.S. Depression, the Great Depression, and World War II. Despite these accomplishments, we remembered Owen Roberts most fondly at Penn Law School for his subsequent decision to step down from the Supreme Court and to become the dean of Penn Law School. As the current dean of Penn Law School, that's a career move for which I have some affection. Through the years, we've welcomed a number of legendary figures as Roberts lectures. From the judiciary, the list has included Justice Felix Frankfurter, Judge Henry Friendly, and Justice Antonin Scalia. From academia, Professors Ronald Dworkin, John Rawls, and Cass Sunstein. We've also honored luminaries who have occupied both worlds, such as Judge Lou Pollack and Judge Guido Calabrese, former deans of the Yale Law School. That brings me, of course, to this year's Roberts Lecture, Dean Harold Koh of Yale, the third administrative impresario from Yale in this series. Dean Koh is probably the most visible and politically active law school dean in the United States today. Through his scholarly focus as well as for his passion for public service, he has helped redefine the role of law professor and dean. It's no surprise that he's been called affectionately Yale's liberal lion and resident rabble-rouser, not your typical description of an academic administrator or professor. His life weaves a mosaic of many synergistic themes: the practice of law, public service, human rights advocacy, academia. As such, he embodies the scholar as public citizen, though I must say in his case, the sum is greater than the parts. Allow me to offer another description: friend. I've known Dean Coe for 25 years. As young lawyers, we worked together in the Department of Justice, and neither of us has aged a day since then. Our offices were next to each other, and indeed we were neighbors. And it was during that time that I observed, as many others, his strong personal convictions in issues such as civil liberties and human rights, views that really have fueled him and energized him throughout his career. Dean Coe's roundabout path to Yale's door began at an early age, not coincidentally, at Yale. When he was 6 years old, he and his family immigrated from South Korea after a military coup. His father, who'd been a minister in Korea, accepted a job at Yale where he taught East Asian law and society. Despite these early formative Eli connections, Dean Coe initially consorted with the enemy in his early educational choices. Leaving the confines of New Haven, he went to Harvard as an undergraduate. There were a lot of Coe defections in those days. I think 5 of his siblings also went to Harvard undergraduate. He went from there to Oxford as a Marshall Scholar. While his siblings, however, went into medicine, Dean Coe chose law as his career and returned to Harvard. The rest, as they say, is history. After clerking for Supreme Court Justice Harry Blackmun, he spent his early years in public service at the Department of Justice's Office of Legal Counsel during the Reagan administration. It was an unusual experience for Harold, to say the least. I remember, in fact, when President Reagan ordered the invasion of Grenada. The next day at the water cooler, Dean Coe predicted that Congress would impeach President Reagan. Well, it didn't happen. But Harold believed, like many other people at the time, that the U.S. had violated international law. It was obvious to all who knew him that Harold's passion for international justice would define his career. In that regard, he found a more sympathetic home years later when he worked in the Clinton administration, serving as Assistant Secretary of State for Democracy, Human Rights, and Labor. Despite his significant government service, the core of Harold's career and his being belongs to the Yale Law School. Dean Coe began teaching at Yale in 1985. Through many years in New Haven, he's built a scholarly and public service identity that is unique. His academic writings are incisive and distinctive and widely recognized both in scholarly and public circles. He's the author of 8 books, including the National Security Constitution, which won the American Political Science Association's Best Book Award on the American presidency. Along the way, he's received more than 25 awards for his work in human rights. From these activities, he is considered a legendary, almost Homeric figure in New Haven. He was so popular indeed that he was the consensus choice for dean in 2004, not a common occurrence in today's frequently divided legal academy. Under his leadership, Yale has extended its reach in a number of areas. He's recruited new blood to an eminent but relatively senior faculty. He's markedly strengthened the public service commitment of an institution already defined by public service. And perhaps most notably, he's built Yale's program, International Law. A man of the world, Dean Coe understands the importance of connecting the practice and theory of law to global concerns. In pursuing these changes, Dean Coe literally lives his ideals, epitomizing the school's reputation for serious engagement with public and international law. Let me conclude with one defining example about Harold Coe. Long before Guantanamo became a locus for human rights abuses, Dean Coe fought for the rights of Haitian refugees. In the early 1990s, the refugees had fled a coup and sought asylum in the United States. But the U.S. Coast Guard, as we know, intercepted them and detained them in Cuba. In what was to turn out a precedent for public interest litigation, Dean Coe organized a group of professors and students to sue the U.S. government for violating the prisoners' rights of due process. The case drew national attention and led to a book, and believe it or not, has now been optioned as a major motion picture. The question, of course, is who will play Harold Coe? The initial betting, of course, is Harrison Ford. As insiders know, Indiana Jones' office in the latest Indiana Jones movie is none other than Dean Coe's law school office, where it was filmed. But everyone realizes that casting the Coe part is a taller order than even Harrison Ford can fulfill. Dean Coe is an original. Today we have the good fortune to have that original with us, the real Harold Coe. The topic of his lecture today flows directly from his academic writings and experience. It's the National Security Constitution in an age of globalization. Please join me in welcoming a stalwart defender of human rights, a scholar of the first rank, a respected academic leader, and the Harrison Ford of legal academia, Dean Harold Honju Coe.
Thank you all very much, and thanks to Mike. Mike mentioned that we were in the adjoining office, at the Office of Legal Counsel. I literally could go into his office so that when our boss, Ted Olson, who later became Solicitor General, would come to look for one of us, we would hide in the other person's office. Also, we were on the same subway line, and my wife was working further down the line. So we would frequently leave together. My wife would get on the train about 10 minutes before. When it pulled into Federal Triangle, she would leap out and look to see whether we were there, and then if we were, we'd all get on together. And so by commuting for several years, we became very good friends. And as I've followed Mike into the decanal ranks, he's one of the people who's been a model to me of how to combine being an academic leader with being a decent person. I should also say how thrilled I am to be here at the National Constitution Center. It's a beautiful building. I came here with my son when he was in high school, and we went through the exhibits. And so it was great to return today. I wanted to talk about the National Security Constitution in an age of globalization. This is, as Mike said, the subject of a book I wrote 18 years ago. And so the obvious question is, what has changed, what has stayed the same, and how can we revitalize the idea of a national security constitution in an age of globalization? Now, if you have not read the book, which makes you among the vast majority of Americans and other people, please buy it on Amazon in the hardbound. There are still some available. The basic idea was that lurking within our Constitution is a body of text and doctrine and custom which makes up how Congress and the President and the courts interact with regard to national security issues. At the constitutional level, text, structure, and the judicial decisions construing them fit together into a kind of framework. Under this are a series of statutes and treaties which frame out responsibilities for constitutional power, including, for example, the Foreign Intelligence Surveillance Act, the War Powers Resolution. And then there's a body of law which, like customary international law, I call quasi-constitutional custom, in that two branches of government essentially agree by practice that something can be done. It's never actually adjudicated, and it could in fact be overturned. So for many years, for example, they agreed that you could have a legislative veto. They didn't formally agree, they just let it happen, until finally this issue was taken to the United States Supreme Court, which ruled the legislative veto unconstitutional. Now, in the book, I suggested three basic lessons about this body of law. One historical, another legal, and the third part political. The historical lesson is about the relationship between law and our national security system. We tend to think of historical episodes of systemic foreign policy abuse, like Vietnam or the Iran-Contra affair, which is what gave rise to the book, as products of human error, not systemic failure. And so if the reason why we have these problems is because bad people are in these jobs, then the solution is to throw out the rascals and bring in new rascals. But what I argued in the historical part of this book is that, in fact, there is a deeper dysfunction in our system of national security decision-making. That the way the system is structured is it creates the wrong incentives. It gives the president incentives to overreach. It gives Congress incentives to acquiesce. It gives courts incentives to defer, which leads to a pattern of, of presidential unilateralism, which occurs on a pretty regular basis. And what it does not do enough is to protect the core idea of the National Security Constitution, which is simply that the system of checks and balances doesn't stop at the water's edge. The idea I wanted to suggest is that the Constitution originally specified that the power to conduct foreign affairs and national security is a power shared among Congress, President, and the courts, but that we don't do a particularly good job in keeping this system of shared power stable. The legal lesson comes from a debate between two competing paradigms, each represented by a Supreme Court case. One is the idea, which I think is at the core of the Constitution, but particularly at the heart of the National Security Constitution, which is that the institution should participate in a balanced way in making foreign affairs and national security decisions. This was most famously set forth in Youngstown Sheet and Tube versus Sawyer, the famous steel seizure case, in which the president seized the steel mills in Youngstown, Ohio, without congressional authorization, and it was struck down by the Supreme Court. Ab Mikva was recently at Yale Law School, the reason being that his judge, for whom he had clerked, Sherman Minton, was a graduate of Yale Law School who had a portrait which had not yet been hung. So they got the portrait painted and they hung it, and I asked Ab Mikva, what was one of the good cases the term you were clerking for Justice Minton? And he said, the steel seizure case. And I said, well, that's interesting, tell me more. And he said that the big debate in the conference was whether the justices who were appointed by Harry Truman would vote with Harry Truman. And that Justice Minton, who believed strongly that you should vote for the person who appointed you, styled this as, are you going to dance with the guy what brung you? And it turned out, of course, that Justice Tom Clark decided to vote against the president and said, said Judge Mikva, the debate in the cafeteria the whole year was, how could it be that a federal judge or a justice of the Supreme Court wouldn't dance with the guy what brung him, who turned out to be the President Harry Truman? Now, this shows that even when the president and Congress are acting in consort or with knowledge of each other's practices, the Supreme Court can strike that down. And here's an interesting fact, that the case that was decided this past term, Boumediene versus Bush, was an example of Congress and the president agreeing that habeas corpus should be stripped from alien detainees on Guantanamo, and the Supreme Court struck that down. Quite a remarkable development. Now, the competing vision to this one of shared or balanced institutional participation is what we call unchecked executive discretion, which is set forth in a case called Curtiss Wright Export Corporation versus the United States. Or the language of that case says the president shall be the sole organ of the nation in foreign relations. When Mike Fitz and I were in the Justice Department, we used to call this the Curtiss Wright, so I'm right site. In other words, the language was so sweeping that if you invoked it, this was always cited passim, or throughout the government's brief, the claim was that somehow this would justify pretty much the president wanted to do. And so the competing visions of the National Security Constitution set forth in these two paradigms are the Curtiss Wright vision of unchecked executive discretion versus a Youngstown vision of balanced institutional participation. Curtiss Wright relying on Article 2 of the Constitution, particularly the commander-in-chief power. Youngstown relying on all three provisions of the structural provisions of the Constitution. Curtiss Wright seeing framework statutes like the Foreign Intelligence Surveillance Act as not exclusive of the president's power, where Youngstown treats areas in which the Congress has chosen to frame out the president's responsibilities as exclusive and confiding his discretion. And then at a technical level, if Congress has implicitly, or not spoken explicitly, it's taken as implied approval in the Curtis-Wright scenario, giving the president the power to act, but it's taken as an absence of approval in the Youngstown scenario. And then finally, the question of the role of Congress and the courts. In the Curtis-Wright framework, Congress and the courts have minimal role in the Youngstown vision. They have a significant oversight role. So these are very dramatic differences in the ways in which presidential power can operate. In the Curtis-Wright vision, you have a strong presumption of presidential unilateralism supported by a very broad reading of the Constitution. Now, in my book, I trace the development of this theme through 6 eras: America's infancy, its rise to a dominant regional power, its development as a world hegemon, the creation of a national security system, the National Security Act of 1947, and then the Vietnam era, in which the system of executive overreaching broke down, leading in the Gerald Ford administration to adoption of new framework legislation: the War Powers Resolution, the International Economic Powers Act, the Foreign Intelligence Surveillance Act. And I ended in 1990 with Iran-Contra and after, another episode which, like Vietnam, was attributed to personal failures as opposed to systemic breakdown. What I've seen in the past 18 years is that, in fact, after the Iran-Contra affair has come to mean the age of globalization, which we now see as having 3 distinctive elements. First, which you could call a period of global optimism, from the fall of the Berlin Wall to the fall of the Twin Towers. This was a period in which people were incredibly enthusiastic about the possibilities of globalization. You could send emails anywhere in the world. You could draw money from an ATM machine. You could fly anywhere. The post-Cold War era, in which suddenly a new world order seemed possible. And then, on September 11th, the planes hit the towers, they hit the Pentagon, and we entered into what could be called the post-Cold War world, which could be viewed as an era of global pessimism. Suddenly, the same instrumentalities, which seemed to give such enormous possibilities, had become sources of danger. The same planes that could fly us around the world could be used as weapons against us. The internet, which was a tool of commerce, could be used to plan terrorist attacks. Ordinary mail system could be used to deliver anthrax. And this is the era in which we've lived for the last 8 years, an era, I call it the post-Cold War world, of intense pessimism, and one in which the economy as well as the political life have been under dramatic attack. If you've just been watching what's going on with Lehman today, you feel it. Which leads us to where we're going to be in January, which I believe, one way or the other, regardless of who wins, will be the new era, the third phase, the post-Cold War world. Now, the interesting thing is that many of the key officials of this past administration learned their lessons about the Constitution during the Ford administration and Iran-Contra. George Bush, 43, Dick Cheney, in the Washington Post today is an excerpt from a book coming out about him called Angler, which describes his philosophy of constitutional law. Rumsfeld, Addington, Scooter Libby. Charlie Savage, a graduate of the Yale Law School, wrote a Pulitzer Prize-winning book, Takeover, which describes what he calls the return of the imperial presidency, which leads to the third lesson, not the historical lesson, not the legal lesson, but the political lesson, which is the vision of unchecked executive discretion is fundamentally self-defeating. It's not a stable one. Presidents who act unilaterally try to trade their short-term freedom, but they end up getting long-term political isolation, lack of support. The success of their endeavors turns on their political popularity or lack thereof, and that by acting alone, they end up without the political support necessary to sustain their initiatives. So to take two examples, George H.W. Bush, after the first Iraq War, Desert Storm, had a 92% popularity rating. And by the end, he was defeated by a governor from Arkansas. George W. Bush, 43, went into Iraq in 2003. Now his popularity is at 18%. So this analysis runs the gamut of our national security policy, a whole range of areas, and I try to chronicle this in the book. And again, the idea here being that this notion, the shared powers notion that should animate our national security constitution, maintaining the checks and balances, is not something that protects itself. We have to protect it, all four branches of government. When I say four branches, I mean not just Congress, the executive branch, the courts, but also civil society, particularly the legal community, but also the media. So, if this is the hypothesis, how does it apply today? And how do we preserve the original vision of the National Security Constitution in an age of globalization? That's the subject of this lecture. Well, what are some features of the age of globalization? First, and obviously, is an interdependent world. Economic developments one place, or environmental developments in another place can affect us dramatically. In the words of Tom Friedman's new book, A World Which is Hot, Flat, and Crowded. The declining power of the nation state, but the corresponding rise of the power of private networks. A young scholar, David Graywall, has a terrific new book called Network Power. The proliferation of problems that cross borders and are inherently global in nature cannot be captured by individual boundaries. And nevertheless, incompletely globalized institutions, rights, and governance as a way of dealing with this issue. Which leads us to where we were on September 11th, when the constitutional vision, I would argue, was basically a vision based on the National Security Constitution. It had four elements: the idea that checks and balances don't stop at the water's edge, a vision of shared power based on the steel seizure case. Second, the idea that there are no zones, practices, courts, or persons outside the law. Third, a simple idea from the Supreme Court case law, Kent versus Dulles, that you should not infringe on civil liberties without a clear legislative statement, that unless Congress and the President have spoken explicitly, you assume that civil liberties shouldn't be limited. And finally, that citizens and aliens have only modest distinctions with regard to particularly social and economic rights. My own father was a permanent resident alien his whole life. He could not vote. He could not sit on a jury, but apart from that, he lived and taught at a state university. He paid his taxes. He rooted for the Red Sox. He liked Fred Astaire. He participated in civic life. He was the president of the PTA. In other words, the fact that he was a non-citizen didn't determine his fate. Well, where are we now, 7 years later? And here I would say that we live in a world effectively turned upside down. For the last 7 years, the administration has pressed a claim of unfettered executive power based on Article 2 and the Curtis-Wright vision. Second, we now have law-free zones. We call them Guantanamo. Law-free practices, like extraordinary rendition. Law-free courts, like military commissions. Law-free persons, who are called enemy combatants. If the administration's theory is adopted, all of them are free from judicial oversight. Third, increasingly, a look to statutes that were passed for other purposes, particularly the authorization of use of military force resolution of September 2001, as a basis for doing all manner of things: data mining, wiretapping, torture. And then finally, a very sharp and growing distinction between citizens and aliens with regard to their rights, particularly targeted if you've been in touch with any of these communities: Muslim, South Asian, Middle Eastern communities. And increasingly, a stunning claim, a transformative claim, somehow the idea that if the president does the act, that makes it lawful. The president's own action is what makes it lawful. This is an argument that was asserted in the torture debate, the idea that if the president orders his subordinates to torture they're acting under the commander-in-chief power. The idea that if the president orders spying or data mining or warrantless surveillance, that trumps the Foreign Intelligence Surveillance Act. The idea that state secrets are protected simply because the president calls them state secrets. Or most recently, a discussion about what kind of long-term security commitment we make to Iraq, whether or not we submit it for congressional approval. Now, this executive action as a law unto itself is significant because the claim is that executive authority can in fact be used to change the rules. Signing statements, this flap over signing statements is the classic example. If the president vetoes a bill, it can be overridden. But if he signs it and says he's not going to enforce it, you can't override a signing statement. Or the use of habeas corpus stripping legislation to shield presidential action from judicial review, such as the Detainee Treatment Act or the Military Commissions Act, or now a remarkable claim that the president can preemptively pardon someone. Scooter Libby, for example, was pardoned even before he was tried. There was no sentence, there was no conviction. Telephone companies and internet service providers have been immunized by statute even before claims have been brought against them under the 2008 Foreign Intelligence Surveillance Act amendment. People who have engaged in waterboarding are, the argument is made, preemptively pardoned. Which brings us to the famous quote by Richard Nixon in 1973. He said to David Frost, "If the president does it, that means it's not illegal." Henry Kissinger put it another way. The illegal, he said, we do immediately. The unconstitutional takes a little longer. He was joking, I think. But when you think about it, there's a deep truth to that. Why does the unconstitutional take a little longer? Because for the national security constitution to be deformed this way requires that the four branches of government acquiesce in a different vision than the original vision that's imagined. It requires the acquiescence of Congress, the courts, the executive, and civil society. Now, in particular, in the last few years, we've seen four disasters. And there are others, but the most prominent, Abu Ghraib, the famous picture. When I was Assistant Secretary of State for Human Rights, I went to Geneva and testified that the United States is unalterably committed to a world without torture, that the United States under no circumstance will use torture, that those who engage in torture or cruel treatment in U.S. Official roles will be prosecuted. Now, when I said this, I had actually cleared that statement with more than 50 government agencies. There was no person in the US government in the year 2000 who with a straight face would make the claim that we had the need to use torture as a tool of official policy. We had a zero tolerance policy. Well, since then, we've gone essentially from a zero tolerance policy to a zero accountability policy. No high-level official has been convicted. The only reason that Abu Ghraib is known is because it was aggressively reported by the press. And the only reason it was reported by the press is because a soldier who was at Abu Ghraib took digital photos and gave it to the press. These reports undermine the government's claim that they should be trusted in the sense that Abu Ghraib was clearly not necessary. No interrogations were being conducted of high-value detainees. Example number 2, Guantanamo. Here is from a New York Times op-ed, the cost balance factor. 3 pending cases, only 1 guilty plea, 300 detainees, of whom only 15 are considered high value. The cost, $54 million for the facilities. Annual operating cost, $100 million. The new building, $11 million. 4 suicides, more suicides than pending cases. 41 attempts, 300 habeas corpus petitions filed. And an amazing group of people who now say that Guantanamo should be closed. The President, the Secretary of Defense, the Attorney General, most of the presidential candidates, most of our leading allies, and yet it continues. Disaster number 3, torture. Jane Mayer's new haunting book, The Dark Side, How the War on Terror Became a War on American Values, has this haunting story that before September 11th, there were only 4 torture scenes on TV a year. Since 9/11, it has risen to more than 100 torture scenes a year. Here's a television show that I like, 24, Kiefer Sutherland. He tortures people at each commercial break. U.S. government officials are regularly seen committing war crimes, and whether it's true or not, an amazing fact, 15 million viewers a week in America, the most exported show by DVD to Morocco and Egypt. In Morocco and Egypt, there's no reason why they should not believe that torture is an accepted mode of doing business on the American side, and therefore why not when Americans are under detention. And a most chilling story told by the people at Human Rights First. When in Iraq, the Bush administration instructed that extreme practices used on Guantanamo should, quote, migrate to Iraq, they freed the interrogators, the military interrogators, of their previous rules, which were to obey the Geneva Conventions. They had never been trained in how to torture. And what ended up happening, according to some of the interrogators, is they watched 24. So they used the practices that they watched on TV on the people before them. It turned out the people in 24, the writers of 24, had themselves never spoken to any interrogators and didn't know that, in fact, very few cases of interrogation are done by torture, that, in fact, torture is generally ineffective, that nobody breaks immediately, that the information they give is rarely accurate, etc. And look at this. Here's a poster from the Cold War era. This is a poster Americans used to discuss what I mean. This is the method of the enemy. We fight to build a free world. We're different. That's what we said then. But now a fourth claim, which is put forward by some academics. Jack Goldsmith of Harvard Law School, in many respects a very admirable person. He, among others, was one of those who protested against the National Security Agency surveillance. But in his book, The Terror Presidency, which describes the whole scenario and the things in which he was involved, he repeats a claim frequently made, that somehow those who would challenge these activities are engaged in some kind of lawfare. And the chapter 2 of the book, the commander-in-chief ensnared by law. Ensnared by law. You know, Jack Goldsmith took my class. The commander-in-chief ensnared by law? The president is a creature of law. That's where he gets his power. He has no power that he's not given. He has no extra constitutional authority. He has no authority to violate the laws. So somehow the idea that he's ensnared by law, as opposed to the empowerment of the president and the restraint coming from the same source, is completely twisted by this idea. And somehow the idea is that the problem is too many lawyers, when I believe the problem is not enough good lawyers put into the loop to give accurate legal advice at the right time, including, among others, Jack Goldsmith. Now, if you accept this analysis, how then do we revitalize the National Security Constitution? As I've suggested, it's a tale of 4 branches, not just one. It suggests that there's a requirement for stronger engagement by civil society, that we should revive a judicial check, that the executive branch should take action, particularly in the next administration, and that there should be stronger legislative oversight. Take a stunning fact, which is the lead of the resistance here has been by civil society, not by government. Congress has been almost entirely acquiescent in this trend. Who has not? The media in reporting Abu Ghraib, the career military in objecting to Abu Ghraib, career government attorneys objecting to torture and national security wiretapping, litigants and NGOs, particularly from major law firms representing detainees. This is something which has gone very deep. So, for example, that wild-eyed, crazy leftist group of radicals, the Librarians of America. The Librarians of America, they are the ones who have most protested against the Patriot Act and actually forced its change. What about the courts? Branch number 2. Here we have a court in which 7 members of the court were appointed by the party of the president, and they have ruled against the administration in 4 major cases. In each of those cases, Justice Kennedy, the key vote. And here are the cases: whether an enemy combatant has due process rights, whether Guantanamo detainees have statutory writs of habeas corpus, whether Guantanamo detainees have constitutional rights to habeas corpus, and then the case in 2006 of Hamdan versus Rumsfeld. Here is the breakdown. Justice Roberts was recused And so the key vote was provided by Justice Kennedy. Justice Roberts had sat below. It happened when he was on the DC circuit. And so it was a 5-3 decision. The basic ruling was pretty straightforward, that the military commission's order was not authorized by the Constitution or by statute. The military commissions violated the Uniform Code of Military Justice, and they violate Common Article 3 of the Geneva Conventions. Now, it seems to me that this was an interesting case because before it was decided, the government argued that it was very important, they must win. After they lost, they argued that it was an unimportant case. All it required was new legislation. It seems to me that this is like what Felix Frankfurter said in Guaranteed Trust Company versus York. There are some cases that are more than great cases. They are a way of looking at the law. And here, what the Hamdan teaches is the president must not go it alone, citing to a broad constitutional theory and blank check statutes. He should fit his actions within pre-existing law, enacted statutes like the Uniform Code of Military Justice, and treaties like Common Article 3 of the Geneva Conventions. It's a much bigger case than just about military commissions. It's the most important case since the steel seizure case about the National Security Constitution. Now, why is this so? Because it seems to me that Hamdan's reasoning properly applied can take us back to the future, as it were, rejecting the dichotomy between law and war that some have asserted, returning us to a steel seizure vision of shared power, rejecting the idea of law-free zones, practices, courts, or persons, restoring the idea of a clear statement principle, and respecting international law, even for enemy aliens. Let me just go back through this. When the planes hit the towers on September 2001, many people described this as what I call a Tina Turner moment. They said, what's law got to do with it? Right? What's law but a sweet, old-fashioned notion? I mean, we're at war. We've been hit. And because we're hit, law has left the picture. It's a war on terror. Well, even if you think about this for just a second, there is a law of war. If you are in the realm of war, that doesn't mean that law is irrelevant. And that's what Hamdan insisted upon. As Justice Kennedy put it, if the military commission is illegal under the law of war, you can't be tried under the law of war by that commission. Second, all justices in the Hamdan case, including the dissenters, including Justice Thomas, Justice Scalia, placed the case within the steel seizure framework. Not a single one of them put it under Article 2 or under the Curtis Wright case. Third, they recognize that even enemy aliens have rights. Hamdan, who was Osama bin Laden's driver, is not a person outside the law just because he's held in Guantanamo, and who can therefore be subjected to the jurisdiction of a non-court. With regard to legislative statements, the court said, and Justice Breyer put it well as his concurrence, Congress has not issued the executive a blank check. It has to be more nuanced than that. And finally, they treated as binding a universal treaty obligation. Now, shortly after Hamdan, I went down to testify before the Senate Judiciary Committee. And one of the senators said to me, Professor, now let me give you a hint. Inside the Beltway, the term professor is not a term of respect. It means ivory tower, know nothing. Professor, he said, the terrorists have not signed Common Article 3. And I said, Senator, the whales haven't signed the Whaling Convention either. Which means this is not a matter of contract. It's not about them and who they are. It's about us and who we are. It's about how we're obliged to treat them as a matter of minimal humane standard and universal principle. Now, the broader implications of this, if you look closely, is that the broader constitutional vision in the Hamdan case undermines the Curtis Wright vision in a whole variety of areas. The president's supposed freedom to torture and engage in cruel treatment, where there's a McCain amendment to the contrary, his supposed freedom to engage in warrantless surveillance in the face of the Foreign Intelligence Surveillance Act, his supposed freedom to try military suspects before commissions that don't meet statutory or treaty-based standards. Now, why is this relevant? Because if you've been paying attention in an age of globalization, you may have noticed that the Supreme Court's transnational docket is growing. From 2004 to 2008, we've had 6 9/11 cases, 1 Alien Tort Claims Act case, 4 foreign sovereign immunity cases, 2 extraterritoriality cases, 2 immigration cases, 1 NAFTA case, 2 federal criminal cases, 2 death penalty cases, 4 cases under the Vienna Convention on Consular Relations, 2 treaty cases, 1 transnational discovery case, a total of 27 cases in a declining docket. Nevertheless, all of our confirmation hearings are about abortion and school busing and vouchers, not about the issues that are actually going to be consuming the future, like what is your attitude toward globalization? And here is the most interesting development, that as in so many other areas, we have an emerging Roberts Court in which 4 justices, Breyer, Souter, Stevens, and Ginsburg, are playing a transnationalist role. 4, Roberts, Alito, Thomas, and Scalia are playing a nationalist role, and Justice Kennedy is the swing justice. So for example, last term, he voted with the transnationalists in Boumediene, the habeas case. He voted with the nationalists in Medellin, the Vienna Convention case. What are some of the philosophical differences? Transnationalists believe in interdependence, a core feature of an age of globalization. Nationalists talk about US autonomy. Transnationalists talk about transnational law, a mixed domestic and international law. Nationalists see domestic and foreign as strictly divided. Transnationalists see courts as having the power to internalize foreign or international rules. Nationalists think only the political branches can do so. Transnationalists see the development of a global legal system. Nationalists believe in the development of a national system. Transnationalists see comedy and the courts as constraining executive power. Nationalists see this as a subject or a reason for deference to executive power. And then the question becomes, where will the Chief Justice stand? Well, if you look over by the post, you see there's a guy with a beard. That's Jerry Newman. This is the Harvard Law Review in 1979. Jerry Newman is now a professor at Harvard Law School. At the time, he was a professor was a professor at Penn. Sitting on his right is John Roberts, who was managing editor of the Harvard Law Review that year. Now, if you look at the door, you see the guy with the beard? That's John Sexton. He's now the president of NYU. And looking next to him is me, smiling away. So the question is, where will Chief Justice Roberts stand? Is he to my left or is he to my right? It depends on which way you're looking. Here is Chief Justice Roberts now. And his credentials are firmly nationalist. He worked on the Iranian hostages case, which was a strong backer of executive power. He worked as a White House and Justice Department lawyer. In fact, he was one of the people who gave the most assignments to me and Mike Fitz in our time. He now has the assignment power. In his own confirmation hearing, he was skeptical of foreign law, saying that using foreign law in constitutional interpretation is like looking out over a crowd and picking out your friends. Now, after he said that, about a week later, Aaron Barak, who's the president of the Israeli Supreme Court, spoke to my class, and I asked him about this, and he said, "What's wrong with looking out over a crowd and picking out your friends? Do you want me to look over the crowd and pick out my enemies?" Now, this is a very interesting insight. What he's saying is, there's nothing wrong with looking for better precedents as a way of guiding your conversation or evaluation. Now, interestingly, last term in Medellin versus Texas, which was the lead transnational case of the term, the question was whether the Supreme Court of the United States should defer to an International Court of Justice ruling. And in the footnote, Justice Roberts cites 2 Moroccan and Belgian cases to say that these judgments aren't binding, but he never mentions a German case about this exact opinion, holding that the Vienna Convention cases should be taken into account by domestic courts, which obviously raises the question, why isn't this looking over a crowd and picking out your friends? And he went on to say, and here's a remarkable result. John Roberts said that the president cannot preempt state law by implementing the World Court's view of US obligations under a treaty. The statute is not binding federal law enforceable without congressional action. Now, the amazing thing is that the John Roberts that Mike Fitz and I worked with would not have deferred to the state prerogative in this area. He, in fact, had worked on the leading case, Dames and Moore versus Regan, which gave him the basis for upholding the president's authority in this matter. In fact, he ruled in a different way. It is a stunningly nationalist outcome. Now compare this with the other Justice Roberts on the Supreme Court, the person after whom this lecture is named. There's a very interesting link between the two people. Owen Roberts died the year that Chief Justice John Roberts was born. As Mike said, he's the dean of Penn Law School. He dissented in Korematsu. He investigated executive handling of Pearl Harbor. He was highly critical of the US military. He investigated the Teapot Dome scandal. And so we have a tremendous irony here, which is the two Justice Roberts of the Supreme Court. We have a 21st century nationalist and a 20th century transnationalist. I'm sorry, that's misspelled. That it is Owen Roberts who has a vision for the future which makes more sense in a global era. And the Chief Justice, who is evincing a different kind of national or contained view at a time in which globalization is the issue. The third possible check or response is Congress. And right now, as you see, we have a 51-48 split. The president's legislative activities have started to be vetoed, followed by overrides, the first override last December, and then a series of pending legislation, most of it now unlikely to pass because of the forthcoming presidential election. And one question is, why is there no legislation about waterboarding? And here you have the emerging theory of the Justice Department, as I've been able to piece it together. Here's Attorney General Mukasey. He says that waterboarding is not happening now. But he will not say that waterboarding is torture, and he will not say that he's going to prosecute anybody who engaged in waterboarding. Why? Because there might be people in the Justice Department who did it. Now, if the Attorney General of the United States was asked whether burglary was a crime, and he answered, I'm not going to answer that question because I might prosecute somebody in the government for having committed burglary, everyone would say, you're the Attorney General, how could this possibly be? Instead, it seems that what he's essentially saying is that there's some sort of balancing test which permits the cruelty of the technique to be outweighed by its potential benefits. If certain procedures are used to approve future waterboarding, they might claim that waterboarding is legal. And so he hasn't called it illegal, he hasn't backed legislation, and he won't investigate or prosecute someone who waterboarded in reliance on the so-called torture opinion. Now, to show that there may be a change ahead, look at this, John McCain, our presidential candidate, who said quite simply, waterboarding is torture. He said this in the face of other candidates like Rudy Giuliani who said they didn't know. He said it was used in the Inquisition, it was used in Pol Pot's genocide, it's being used against Buddhist monks today. One of the strongest voices against waterboarding in the Senate. And an interesting statement, really one that could have been said by his opponent, Barack Obama, in the Financial Times. We recall that we must pay decent respect to the opinions of mankind, the words from the Declaration of Independence. We have a duty to live up to high morality and international responsibility. We can't torture or treat inhumanely terrorists. We will fight the terrorists and defend the rights that are the foundation of our society. What about Obama? He says it similarly. We'll lead by maintaining the highest standards of civil liberties and human rights, which is why I will close Guantanamo, restore habeas, and say no to torture. And then he says, I've taught the Constitution, I believe the Constitution, I will obey the Constitution. So, if these individuals, one of them will become president, what will then be the constitutional legacy left behind by the Bush administration? The two leading legacies, obviously, the two justices, Roberts and Alito. There were some proposed constitutional amendments, some proposed modes of constitutional interpretation that have been put forward as theories, either unitary, executive, but will there actually be a shift to a Curtis Wright theory of presidential power? And notice that even those who originally backed this, Jack Goldsmith at the end of his book says, in the war on terror, the president has been inattentive to soft factors of legitimation, like credible expression of public concern for constitutional values. And so he's seen his soft power diminish. All he's repeating now is the thesis of the National Security Constitution, but at the end of saying that the president is ensnared by law and captured in lawfare. Well, if you were the president, the new president, or the new Congress, how would you put your house back in order? And let me just very quickly suggest a number of simple responses. 4, close Guantanamo, issue some executive orders, propose national security legislation, and show new respect for international law and institutions. Closing Guantanamo. This is a complicated process. Why is it taking so long? Because the fact of the matter is that if people were brought to Guantanamo who never should have been brought there in the first place, it's very hard to get them off. If you take them to countries where they might be tortured now, they're out of the frying pan and into the fire. And this requires delicate cooperation between many agencies, justice, state, defense, intelligence, and the White House. And as you saw, the detainees have to be split into those who should be prosecuted by being brought onto US soil. Those are the high-value detainees. Those who should be extradited, those who should be repatriated, and those who could be resettled or guaranteed asylum. Now, my own view on this is quite simple. There are 2 precedents available to us. One is the Iranian hostages crisis, where the Carter administration worked with the Reagan transition team and actually got the hostages out by Inauguration Day. And what they did was they used the pressure of a new administration to get diplomatic results. The negative precedent is President Clinton coming in 1992 when the Haitian refugees were on Guantanamo. A case was pending at the Supreme Court. There was an effort, I was part of it, to try to get the Clinton administration to drop the case and take people out of Guantanamo before he assumed office. But once he assumed office and they were still there, the policy lingered for a couple of years. So my own recommendation is that we should not wait, that on the day of the election, the day after the election, November 5th, if Obama, for example, is elected, they should appoint someone like Bill Richardson as a special envoy. And he should go around to the countries which have the most detainees, the Saudis, the Yemenis, the Algerians, and make deals with them in which he says, if you want diplomatic recognition from the Obama administration, you must take your detainees off and give us adequate diplomatic assurances that they won't be tortured, which we will monitor by having human rights groups, the Committee on the Red Cross, US embassy officials going to check on their status. Meanwhile, I believe that the Defense Department should start to shut down Guantanamo, that the Defense Department's detainee affairs ought to be answering to human rights lawyers. The Justice Department will have to appoint a point person, and meanwhile, incoming lawyers at the many offices, White House Counsel's Office, General Counsel's Office at DOD, and the Office of Legal Counsel, where Mike Fitz and I worked, have to read all of these secret opinions and decide which ones of them are actually good law, and withdraw them. Withdraw the ones which are in fact bad as a matter of law. On executive orders, there are at least 6 I think they need. To close Guantanamo by a date certain, to make it clear that no torturing, cruel, inhuman, or degrading treatment or waterboarding can be done, to clarify the scope of the authorization for use of military force, to establish a national security law committee chaired by the Attorney General that can make sure that the rule of law applies on national security affairs, to create an independent commission like the 9/11 Commission to look into issues of accountability for past acts of gross violation, and finally, to make it clear that we will not avoid habeas corpus by moving detainees to various black sites through methods such as extraordinary rendition. With regard to national security legislation, in my book back in 1990, I proposed national security charter legislation. The proposal is still there. I think we should repeal the Military Commissions Act, revise the Classified Information Procedure Act. There are some people who have suggested, and this is on both sides of the aisle, that a proper response to the closing of Guantanamo is to create a special secret terror court by federal judges which would operate in secret and try cases. And this is an utterly bizarre suggestion. It suggests that after all of this time, we have accepted the idea that our standard of justice is now, at least it's better than Guantanamo. And nobody asks, will preventive detention be a place in which terrorists are created, just as they were in the British prisons in Northern Ireland? And nobody asks, will anyone in the Middle East think that a secret conviction by a terror court of a Muslim is in fact legitimate? And finally, Obama himself I think, unfortunately, cooperated in the enactment of the Foreign Intelligence Surveillance Act amendments. It was done in haste, and in the lead up to the election, perhaps there's a chance to revise that as well. And finally, with regard to respecting law and institutions, the International Criminal Court, which the Bush administration has attacked, it has in fact cooperated with consistently for the last 4 years. We should switch our policy from one of hostility to active support. We should prosecute the Darfur case and support the prosecutor in doing so. There is a genocide prevention task force with a set of very sensible recommendations as to how genocide can be monitored within the US government. There are lawyers in the US government whose job it is to promote accountability. We should rejoin some of the major UN human rights mechanisms like the UN Human Rights Council. And there are a variety of treaties that we could and should ratify, from rejoining the Kyoto negotiations to the Convention on the Law of the Sea, the Covenant on Civil and Political Rights we've already ratified, but not economic, social, and cultural rights, the American Convention on Human Rights, and the Convention on the Rights of the Child, which the United States is the only country in the world that has not ratified that except Somalia. Their explanation is they have no organized government, and we have no explanation. Now, the amazing thing here is two thoughts. First, that our focus on the war on terror has really driven out most of the other issues which are on the foreign policy agenda. We simply cannot afford to spend the next 4 years on such a narrow piece of the agenda. Just take Iraq, Russia in Georgia, North Korea, Cuba, where for all we know, Castro is alive or dead, North Korea, where for all we know, Kim Jong-il is alive or dead. We haven't had a Middle East peace process, all of the global issues, the relationships between US and international bodies. And so I suggest that the next 4 years will be a tale of 3 globalizations: the globalization of governance, the globalization of freedom and democracy, and the real question being, how can these two be used to attack the problem of the globalization of terror, as well as the globalization of disease, the globalization of environmental injury, so many other kinds of problems. So how do we protect the national security constitution in an age of globalization? It's up to the executive branch to use respect for the rule of law to promote cooperation. It's up to the legislative branch. It's up to the judicial branch to ensure a system of checks and balances and respect for the opinions of mankind. And it's up to civil society like us, citizens, lawyers, law schools, media, bar associations, academia, to monitor our government and hold them accountable. Because recall the basic lessons. It's not about bad people, it's about a dysfunction in our system, which creates bad incentives for the executive to overreach, for Congress to acquiesce, for the courts to defer, which leads the president to act without legal or political support. It could happen to President McCain or President Obama. And moreover, that it's fundamentally self-defeating. The more the president acts alone, they end up in political isolation. They gain no political support or legal support, and at the end, they're left with their political popularity or the lack thereof. Will the war on terror transform the national security constitution? I think it depends. Will there be another attack? Will the surge succeed? Will we face a drawdown? Will the executive branch change and stop pressing these theories? Will the legislative branch get some backbone? Will the courts continue, as they did in Hamdan, to apply the principles of the Steele seizure case? And most important, it turns on whether civil society, us, individuals, continue to monitor government and hold our leaders accountable. Because remember, at base, this is our national security constitution. It's not self-executing. Maintaining checks and balances is our job, not just the job of governments. Politicians will do what they want. They will follow politics. But why is it so important? We sit here at the National Constitution Center, and more than anything else, our Constitution, our system of checks and balances, the core of these ideas define who we are as a nation and a people. Maintaining our national security constitution and revitalizing is not a task we can leave to politicians who will have other priorities, like getting elected, like getting reelected. And the fact of the matter is, if we do not protect our own Constitution, we don't protect the thing that makes us fundamentally who we are. It seems to me that this task, revitalizing the national security constitution for an age of globalization, is the quintessential 21st century for we the people. A good message for Constitution Week, a good message for all of us here. Thank you very much.
Harold, that was truly a tour de force, an extraordinary Roberts lecture. I know we talk a lot today about integrating theory and practice, but that presented truly a grand vision of international law and then broke it down both historically as well as practically what it means both over the last 10 years, but what it should mean over the next 10 years. I think, needless to say, Justice Roberts would be quite proud that this was the lecture given in his name many years later. Really a tour de force. I really want to thank you for that address. You know, I was worried that you wouldn't say what you thought when I asked you to come here. But I guess I know you held back, but I just wanted. In any event, we have an opportunity for folks to ask some questions, and I'm sure Harold will be as restrained as he always is. But why don't we begin here? Sir.
Can you explain to this audience why graduates of the top law schools of this country were convinced to write legal memos subverting the Constitution of the United States?
Well, for a couple of reasons. First, because they never thought those memos would be seen. You know, Mike and I wrote these opinions. We were in the Office of Legal Counsel. When we wrote these opinions, the first thing we said was, what if this appears on the front page of the New York Times? Now, these were, quote, classified opinions. Secondly, they were written by a very small group of people. The convening force for this was the Vice President's Council. Now, if the Vice President's Council had called me or Mike, said, I want you to do something, we would have said, when you call the Attorney General and he asks us to do it, then we'll do it. But we don't work for you. You're not in the chain of command. But the fact of the matter was that a very small war council got responsible. They started to develop the actions, and then particular lawyers were brought in and asked to write these opinions for events that had already occurred. It was a post hoc papering the file exercise. It wasn't a ex ante neutral decision about whether it's lawful or not. The torture opinion is the clearest example of this. If you look at the torture opinion, which is extremely long, the first footnote says, someone who tortures someone, if it leads to their death, they can themselves get the death penalty. That's what it says. That's the statute, the War Crimes Act. Now, as has been reported, there are 1 million books on this now. Bush's Law by Eric Lichtblau, The Dark Side by Jane Mayer, Takeover by Charlie Savage, this book Angler, about the Cheney vice presidency. The United States had in custody a man named Ali Zubaydah. They were subjecting him to torture. People who were torturing him had been trained not to do this, but they thought, if I do this and he dies, I'll get the death penalty. And they said, I need shelter. Give me shelter. And then the question was, how can you write this opinion in such a way that it's essentially a get-out-of-jail-free card? Now, you know, if you're called, you know, when we were in the Office of Legal Counsel, if you were called and told this is happening already and we're just looking for a post hoc justification, you say, I can't do it. You know, why should you act as a yes man for something that's already happened as opposed to actually participating as a lawyer? So that's essentially, I think, what happened. Now, there were channels of breakdown. Much of this was happening in secret. And, you know, there was a feeling of terror. I mean, Whatever you want to say about John Yoo, he did a lot of work product in a very short period of time. He wrote a tremendous number of opinions. It turns out that, they look like it. If you write 1 million articles in a month, they're not going to be that good, and the research isn't going to be that detailed. But it's not that hard to do if you know the result which you're trying to get to, which is the president can do it. Now, there's quite a remarkable thing, which is for 4 years, there was a secret program of national security surveillance, wiretapping and data mining. And when Alberto Gonzales was nominated to be Attorney General, at his confirmation hearing, which I attended, he was asked by Senator Feingold of Wisconsin, what if what you're doing is inconsistent with the Foreign Intelligence Surveillance Act? And he said, well, that's a hypothetical situation. Later on, it turned out that they had been wiretapping in violation of the statute. At which point Gonzales said, well, if the president ordered it, it was within his commander-in-chief power, and he wasn't constrained by the statute. That's what I mean when it says, if the president says it, it's not illegal. Now, let's be honest here. The president was surrounded mostly by strong policy people and weak lawyers. The lawyers weren't there, or if they were there, they were brought in late. Or if they were brought in late, they weren't people who were going to actually challenge the decision. I mean, we're not talking about Edward Levy here, to take a Republican example. We're not talking about Nicholas Katzenbach. So when you have lawyers who are not in the decision-making process, when those people are essentially being asked to give post hoc justifications for things that are already happening, when they're being told that people in the government might be given the death penalty for defending their country, that's when they come up with theories like torturing someone in self-defense. That's one of the theories that emerged. I'm torturing you in self-defense.
Thank you for a tremendous talk. Nice to see you here in Philadelphia. I have two related questions, one an institutional one that leads me to kind of a question about Supreme Court doctrine. When you were discussing your model of institutional control, you mentioned the executive branch itself, and then Congress, the courts, and the civic society. And in discussing events of the last 7 years, you gave senses where both civic society and the courts have stepped in meaningfully. Notably, I didn't hear an example since the Ford era in the 70s with FISA and the War Powers Act where Congress has lived up even minimally to its oversight role. And you mentioned the tendencies toward extreme congressional acquiescence. So the first question is, do you think there's any hope is there any hope for Congress in playing a meaningful oversight role, and or are we kind of stuck with a supine Congress on these matters? If so, if that's true, if Congress is no longer meaningfully exercising oversight, it would seem to me to cast doubt on Jackson's tripartite framework, where he says famously in Youngstown, as you alluded to, that the president's power is at its maximum where Congress grants it, at its lowest ebb where Congress withholds it. But that seems to presuppose a Congress that does meaningfully ratchet up or down its oversight. And if Congress isn't doing that, is it time to move away from the Jackson test?
I don't think it's time to move away from the Jackson test, but I think this tradition of congressional supineness has really gotten out of control. The greatest example being the Patriot Act. The Patriot Act was enacted in the wake of 9/11. Everybody acknowledges that most of the provisions in the original Patriot Act were ones that had been kicking around, and when they were told to put together a law, all of the kind of wish list of various prosecutors were put into a single bill. But that's not the catch. The catch is that none of the members of Congress even read it, right? Anthrax was in the building, and so it was a very long document. I mean, Michael Moore, in fact, I think in his movie, much criticized, Fahrenheit 9/11, goes and asks people, did you read the bill? They didn't, so they just voted on it. Now, well, that's not that very good, voting on legislation you haven't read. How about this? Having no hearings. It'd be nice if Congress had some hearings where they actually called witnesses and asked them questions. Most of this legislation has been done in the waning days before an election. A lot of it has been done by writers on appropriation bills like the McCain Amendment. And if the problem was a closed groupthink process, The response to that through a democratic process is supposed to be to have open congressional hearings where people appear and debate the various sides of the issue. Now, will that change in a new administration? Well, we are influenced by the fact that both presidential candidates are senators. So they ought to be sympathetic to Senate hearings. Secondly, that the vice president of one of them, candidates, Joe Biden, is a person who loves oversight. So it's possible that there will be a lot more legislative activity. But the point I'm trying to make at the last part of the presentation, which was very technical, is the period of the transition is extraordinarily important. You know, Barack Obama must be completely exhausted. I mean, this guy's been campaigning for several years now. Nevertheless, he has a transition team. So does McCain. The quality of decision-making of these teams could be debated, right? I mean, John McCain won de facto, was the presumptive nominee in March. But all indications are a selection of a vice president happened the last half day without vetting or without a lot of vetting. So the real danger is that the burdens of the campaign may diminish the most important aspect of which is the transition. Now, you know, in the Clinton administration, Walter Dellinger of Duke was one of the few lawyers in the government. And his job was to draft a number of executive orders. And some of them were issued. There was also discussion about some things that could be done. One of the things they picked early on, which was gays in the military, turned out to be a disaster. And because of that, they had to then backtrack. I really want to emphasize how important the period from November 4th until January 20th is. And, you know, it's 10 weeks. In 10 weeks, after the election of Ronald Reagan, the negotiations with the Algerians to get the release of the hostages threatening the arrival of Ronald Reagan made this possible. Now, I had originally been told that after Boumediene, the habeas case, the Bush administration would close Guantanamo shortly thereafter. As you know, that was decided in June. It's now September. It hasn't happened. I think they've essentially decided to leave it to the next administration. And the real question ought to be, does the next administration really want to have Guantanamo on its hands? For them to make the maximum use of their time, they have to get their justice, state, intelligence, and White House communities organized now. They have to connect with their counterparts on November 5th, and they need to engage in extensive diplomacy of the kind that this administration has barely done and close Guantanamo so the new president, whoever it is, takes office without Guantanamo being open. Now, at the end of the day, a couple of people come to a supermax prison in Colorado. They have a right to petition for habeas corpus. They've got it anyway. A number of people are repatriated. They have to get diplomatic assurances. A number of people are resettled or file for asylum. A number of people get extradited. You could figure this out now. I'm sure they have a plan for this. The question is forcing them to implement that plan. So my point on this is I think that Congress can be a factor. Certainly, if McCain wins, you'll have a Democratic Congress opposing a Republican president. I'm sure there'll be a lot of oversight then. I mean, the question is, what would be the quality of that oversight? But I do think, ultimately, it's the internal system of checks and balances within the executive branch, an open process, really run by the White House with very able lawyers. You know, there should be a very able Attorney General, there should be a very able White House counsel, there should be a very able National Security Council advisor, there should be an able Secretary of Defense, and all of these people should have the job of making sure that the law is obeyed. So I think it can be done. If it's not done, we could be looking at another few years of this. And here's my most important point. As tired as you are of the last 7 years, the next 8 years are so much more important. Because who knew that the pendulum could be pushed so far, so fast, that it will require that it be brought back to where it was quickly. And if you start to embed some of the worst features, like a terror court then we have suffered a paradigm transformation. And we are now living in a new normal in which it doesn't matter who's in power. They all accept the Curtis Wright paradigm rather than the Youngstown paradigm. And you can legitimately ask the question, is steel seizure no longer good law? Now, my argument is steel seizure plus Hamdan is the law. So, no, it's not bad law. But we've got a court in which the next appointment is going to make the difference, or the next few appointments. Nevertheless, when those people are nominated, they never ask them about this kind of thing. They ask them about, what's your attitude about the issues of the past? Will you overrule a case that's 30 years old or 40 years old?
Very quick. Thank you very much for that good lecture. I thought law supposed to serve justice, but when law sets the terrorists free, don't you think we're supposed to change the law in order to keep the terrorists behind or serve justice to the terrorists? I mean Hamdan, you know.
Well, I recommend to all of you the Human Rights First report examining 120 terrorism cases before 9/11 that were tried in civilian courts. 2 career prosecutors analyze all those cases and suggest that terrorism cases can be prosecuted effectively in civilian courts with modifications. Now, if that's so, why do we create a new ad hoc system? Why do we create military commissions? The military commissions were created in 2001, and we're still waiting for outcomes in almost all the cases. It certainly has led to swift justice. All it's led to is multiple challenges before the Supreme Court because they're so manifestly below constitutional and international law standards. So I agree. Law should be modified in light of the circumstances. But if you read the Hamdan case, what they say is regularly constituted courts are the secret. You know, habeas corpus, in the Boumediene case, they say, is an attribute of the separation of powers. I think Justice Kennedy says, you know, security and liberty subsist in fidelity to our first principles. In other words, they're saying, let's not create a whole new regime, let's stick to the old regime. And that's exactly what hasn't been going on. You know, throwing out 100 years, hundreds of years of precedent, when in fact it can be adapted for this purpose. That, I think, has been the failure. Now I think we're in a situation where if everybody, you know, McCain and Obama are agreed that they are not going to do, or they say, we're not going to go so far. So if that's so, perhaps it's possible that you could have a legislative effort now with the loser still in the Senate and leading the way. If they can still agree on anything, who knows?
Well, I think the length of that applause says it all. I won't, let me say I started out by commenting that this room indeed has its own constitutional history now. This is where candidate Barack Obama gave his well-known speech on race relations. And needless to say, I think this is a equally, indeed, perhaps even more extended, thoughtful discussion of issues facing our country, in this case, the national security constitution. So this has really been extraordinary. I want to thank you all, and I suspect Harold will hang around for at least some time to answer any more specific questions. Thank you again for coming.